And thanks for waiting for us here on YouTube Live. Just switching over some of our technical things here to go from TV to continue the conversation here on YouTube. We have our legal expert, Rick DeToto, in studio once again to join us and kind of break down some of the big developments. Rick, how are you today?
I'm good. How are you?
Good. It's been a long day. I mean, it was really emotional in there, seeing the family of Joseph Hartsfield tear up several times and really have trouble talking about the final days with him. And so I wanted to pick up with you, though, right where we left off on TV, and that's with these extraneous offenses, these alleged past crimes or bad acts that Sarah Hartsfield has never been convicted of. When we talked last night, you did express some concern about those things being brought up during the trial. And I do want to show everyone here kind of the main one that came up from both witnesses that testified today. We've got David Bragg, who is an ex-fiance of Sarah Hartsfield. He was also, according to his family, making plans to leave her in the time leading up to his death. And in this case, he was fatally shot back in 2018. At that time, it was ruled self-defense. But then after Sarah got indicted for murder here in Chambers County, just days later, the prosecutor's office there in Minnesota told us that they had reopened the investigation in light of some new information that came into the sheriff's office. So since we did end up hearing some of that testimony today, Rick, I want to just get a sense from you, your initial thoughts to that, and then we can dive into it a little bit more.
Yeah, so I think it's really dangerous for the defense, and I think in a way the fox is now in the henhouse regarding the extraneous offenses. Just because a defendant gives a statement, and defendant statements are generally admissible in criminal trials, doesn't mean it overcomes the high burden of allowing extraneous offenses that happened in the past to prove that the person conformed with that in this case. It's really dangerous in my opinion. I think that the defense lawyer is trying to do everything he can to keep that out, but just because she told them about those doesn't mean it's admissible in this case, and it puts the defense lawyer in a difficult position now because he has to rebut those claims. For example, in the shooting of the older husband, it was ruled self-defense, and I think there's an opinion of that by the city attorney. He's going to now have to introduce that into the proceeding to rebut what's been said at this point.
So we have seen that some of that the law enforcement that investigated that case back in Minnesota has been subpoenaed to testify here. We don't yet know if the judge will let that law enforcement officer testify or not. But now that this has come up and both the witnesses talked today about that shooting and hearing about it from Sarah, do you think that then kind of lends itself to ultimately having that law enforcement officer testify, or what do you think?
Yeah, it's hard for me to speculate on that, on what the court is trying to do regarding the extraneous offenses. I think the ruling, as I understand it, was that it was an admission by the defendant, so it comes in. But now the door is wide open. So does that mean that the prosecution can bring the law enforcement officers like you discussed, and then the defense has the right to bring any evidence to rebut that? Now, if I'm the defense lawyer in this case, I kind of want them to bring that in at this point because I have a written letter from the city attorney saying that it was self-defense, that he's not going to charge her, and that kind of stood in this case. So it's going to be really interesting to see how both sides handle that information.
It will be interesting, and it sounds like the judge will likely be kind of ruling as each witness comes in on what they can or can't talk about under that section when we're talking about these extraneous offenses. I also want to ask you about proving this murder, because we talked about this last night, and it's, you know, there is no specific manner of death that's been determined by the medical examiner's office in this case. So her defense attorney, Case Darwin, he did bring up during his opening statement today that, you know, the state is not going to be able to prove how much insulin Joseph Hartsfield ultimately had in his body. The state in their opening statement really didn't say who gave him the insulin or how much he was given. And in this case, they even specifically said that the insulin pens that they found as part of this investigation were not even tested for fingerprints. Is that going to be an issue here?
Absolutely. I think that's the defense's main defense in this case. I don't think I've ever seen a case in my almost 30 years where the prosecution has stood up an opening statement and not given a reason or how the defendant committed the murder in the case. We're taught as lawyers in law school that in opening statement, it's super important to get across what your theory of the case is. This is what happened, this is who did it, and this is how we can prove it. It sounds like they're just saying she did it, but we don't know how she did it, and we'll let you know as we get there. So I think it's going to be a tough case for the prosecution at this point. They may be holding back something. Maybe that's their strategy. There's something we don't know about. But absolutely, if I'm the defense lawyer in this case, I'm harping on the ME's determination that there's no way to figure out how this person died. And specifically, they didn't test the pens that were at the side of the bed. No fingerprints, no contact DNA, no evidence that she caused him to have the insulin or overdosed him. So again, it's another very interesting part of this case that I'm curious to see how that gets handled.
If the prosecutors did have that information and they knew exactly who gave him the insulin and when he got it and how much he got, do you think they would have revealed that today, really on the first day that we heard any testimony?
Absolutely. And if they didn't, they probably shouldn't be trying cases, because that's the most important part of your case. You want the jury to understand at the very beginning, this is what happened and this is how we're going to prove it. And this is the evidence that shows that this person did it. So I suspect that they're a little bit worried about how that's going to play out in terms of the trial. So maybe they didn't want to overcommit, but it's a big glaring hole in their case at this point.
I want to ask you about something else that we heard during the opening statements from the prosecutor, though. She told the jury, she warned them, and we have some video again that I want to show in case anyone didn't see it on TV. This was Sarah Hartsfield arriving here at court today, and the prosecutor did say to the jury, she said, you know, be ready for the defendant to be on and performing during this trial. Again, from this video that you can see, Rick, she appears to be carrying that Bible inside that she kept with her. And then once we saw her inside the courtroom, she had a ring on her wedding finger. We don't know for sure if it was her wedding ring or not. But what do you make of her bringing the Bible in and the message that she may be sending here or trying to send to anyone who sees it?
Well, it's dangerous and because that the jury can see through it, but I think she's trying to send the message that she's a religious person, that she's an honest person, that she can be trusted, and that she's a good person. So she's trying to use the Bible to send that message to the jury. But I've had a couple of clients in my career do that, and I think it kind of backfired on them, especially in a case like this. You don't want to do anything to draw attention to yourself or to draw scrutiny to yourself. So it's probably not a great move on her part, but I guess we'll see how that plays out.
Yeah, and I also want to ask you about the bling, honestly, because I saw the ring today. I saw a bracelet yesterday. Are defendants who are usually in custody, do you see them come to court for their trial? I don't know what else to call. I mean, in the bling and really showing up for that.
Yeah, we typically don't see defendants that are in custody have the ability to let the jailers put on all kinds of jewelry and stuff like that. But most importantly, as a defense lawyer, I tell my clients in trial, you want to be very conservative. You want to be very low key. You don't want to have flashy rings or earrings or anything that draws attention to yourself. So, you know, I don't know who's advising her on that. It's not something that I would advise my client to do. Again, it's a little eccentric and it's going to draw attention to herself, and that attention may not be wanted by the jury.
Yeah, understandable. We'll have to wait and see, and I'll, you know, of course, keep notes on what else we see that she may show up with or have on when she comes in for court in the future days of this trial. A lot of the testimony that we heard this morning really did focus on what the family described as the terrible, tumultuous relationship between Joseph and Sarah, especially in the weeks and maybe even months leading up to his death. The family also talked a lot about how they feared for his physical safety. And one of the messages that Sarah Hartsfield sent me from jail back in 2023. I believe we have the graphic of that to show you. What she said in that message was this. She said, quote, "Our marriage was never toxic. We had run-of-the-mill first-year issues combined with the fact that Joe's family couldn't let him have his own life." I hope we can have that graphic to show you. That's not the right one, but we do have it somewhere. And I'm just curious, Rick, by them talking about all these issues and letting the jury hear about how everything was leading up to his death, what do you think that may help the jury understand here? What do you make of that?
So I think the prosecution is trying to set up a motive. While they don't have to prove a motive, it's very helpful in cases like this, and they're trying to show the background situation between the family, the defendant, and the complainant, in that they were fighting all the time, they were super unhappy, they were miserable. There may have been some very serious fights, and I think he made a statement that he made it home without getting shot. So they're trying to show the background of what's going on in this family and the motive for her to, I guess, not treat him when he was going through a medical crisis. So it's a smart tactic by the prosecution to show all was not well in this house and that potentially he was going to leave her and she did not want that to happen.
You mentioned that he made it home without getting shot. For anyone who hadn't seen the live blog that we're keeping updated on click2houston.com, there was a voicemail that got played in court today. And in that voicemail, it was Joseph Hartsfield calling his mother. He said, "Hey, I just want to let you know everything's fine. I went back home to Sarah and prepared to be shot," I think is specifically what he said, "but it didn't happen. Anyways, I love you, bye," and he hung up that phone call. So that was played also. And again, in hearing all of these things that were discussed, Rick, keeping in mind the makeup of this jury, we're talking about 8 men and 4 women who are hearing this. Is there anything that you would say just about that and kind of how that may play with them as they're hearing some of this?
So it tells the jury that in the complainant's mind, there were some serious concerns about harm being done to him. So he was so worried that the defendant may potentially harm him, shoot him, kill him, stab him, whatever it may be, that he called his mom, maybe it was jokingly or however it was, to say, "Hey, look, we got into a fight or whatever was going on in our lives, and I made it home without getting shot." The difficult, very difficult part about that as a defense lawyer is we cannot cross-examine the person who made the statement and say, "Were you joking? Was it in jest? What was going on?" So I think that's a really impactful statement at this point in the trial for the jury to understand that he was concerned for his safety at the time.
And we talked again about some of the text message evidence that came up in court today, messages that Sarah had sent to Joseph Hartsfield's family. I saw a binder of messages between her and Joe that we haven't even heard about yet. And everyone who I've talked to who knows Sarah, her exes, her family members, you name it, they say she really likes to text. She likes to kind of have these blow up rants, if you will, over text messages. And some of the testimony that we heard today was, the mother of Joseph Hartsfield saying that the messages that she would receive from Sarah were really long in comparison to messages that she received from anyone else. I know that firsthand, too, based on just some of the messages that she has sent me from jail over the time that she's been in jail. So what do you see happen most often when it comes to the text messages? Because obviously the prosecutors have that evidence in this case. I'm just curious, is that kind of where the secrets may hide and people may end up getting caught?
A lot of times there's some very embarrassing evidence that leans towards guilt in text messages. It happens all the time in criminal cases. It happens all the time in family cases. So I tell my clients, I tell my kids, I tell everyone I know, don't put anything in a text that you don't want to see in a courtroom overhead in front of a jury. And I think we talked about that earlier. It's not uncommon for people in relationships that are fighting to send very aggressive, difficult, profane texts to other people, their husband, their boyfriend, whatever. And you never know when that's going to show up in a courtroom and be used against you in a murder trial or whatever it may be. So it happens all the time in court, happens all the time on email, social media. It's pretty common in our society right now.
Yeah, I mean, for people who weren't in the courtroom, obviously you've been in and you know how this works, but the prosecutor would pull out a page and it was like a screenshot of a text message and she would show it to the witness and then the witness would verify, yeah, that was a message or that I got or whatever, and then she would slide it under the projector up for the jury. I always tell my friends even, just don't text it if you wouldn't want it read in court, because we saw that, and I think that we can expect to see a lot more messages come up throughout this trial. Rick, just based on kind of the timing of everything, we heard from 2 witnesses today. It was the opening statements, which really didn't take too long, and then it was 2 witnesses. And we know that the state has a witness list with about 86 or so people on it. What are you thinking when it comes to the timing here of everything? We've been told it could take up to 3 weeks.
Yeah, sounds like it's going slow. 3 weeks is probably a good estimate if they really are going to call 80 witnesses. I think they're going to lay the groundwork for the family, get through all that, and then start getting into the medical evidence to try to prove why they think this person is guilty of murder. So it could take 3 weeks. As trials like this get to the middle of it, everyone kind of gets tired, including the judge, and the judge will start moving things along quicker. And sometimes prosecutors make decisions that they don't need to call these extra 10 witnesses because they've already proven what they have. So it's fluid, but 3 weeks sounds about right at this point.
And I know you've been in the courtroom, you've been on some big cases before. Take us behind the curtain just a little bit, because, we're seeing these attorneys in the courtroom before 9 o'clock working through things. We're seeing them until, 4:30, 5 o'clock, sometimes staying later and then working through it. Like, what's happening in the evenings? It's not like they're just going home and resting, I would assume.
Yeah, normal trials are difficult enough, but when you have a high-profile case where there's a lot of scrutiny on what you're doing, you are 24/7, nonstop, figuring out what you're doing. You're reacting to different things that happen. You're trying to strategize based on what happened the day before. So you don't get much sleep. You don't eat much. You kind of just get into combat mode, and you're taking in all the information. You're trying to make very difficult decisions with limited information. So that defense lawyer I know is working 18, 19 hours. I'm assuming the prosecutor is, and it's just nonstop for 3 weeks. So yeah, that kind of what goes on in these high-profile cases.
One last question for you, because I know there are a lot of witnesses who are in town from out of state or from other counties in Texas, and they are, waiting to figure out when they might get called to the stand. Is there any strategy that the state may have kind of on the order of who they call and when they call them?
Yeah, I'm sure they've thought that through. They've tried to figure out who the most effective witnesses are. Generally, you want to put your least effective witnesses kind of first and maybe in the middle. You want to end with a bang. So I'm sure they've obviously talked to everybody. They know their personality. They know if they're going to be articulate. They know what information they have. So they're trying to figure out how that plays in the trial. Trial is a theater. You're trying to weave a story in and out through what's going on to prove the person's guilty with a whole bunch of other stuff going on. So it's complicated, but I know they have some type of strategy in the witnesses.
It's interesting you say that about putting the least effective witnesses first, because honestly, sitting in there today and just hearing the emotion that came from the mother and the sister, it seemed really impactful. I think that, there were some people who might have also been visibly emotional because of it as well, but maybe it's the science and things that will come in more effective later in this.
Yeah, as the trial goes on and the jurors get tired of sitting in trial 8 or 9 hours every day, the first days of the trial, the first week of the trial is kind of going to fade and all that emotion is going to go away. So that's why you kind of have your best witnesses towards the end of the case, so it's the most impactful, it's in their memory the best, and it's more recent.
Well, that makes sense, Rick. Thank you so much for breaking down some of the big things with us today, because there's so much happening with this trial, and we know that this is one of the biggest murder cases that Chambers County has seen in years. There's a lot going into it behind the scenes, so I really appreciate you helping explain some of this. There's a lot of questions that I have, so thank you so much. We'll, of course, check in with you again as the trial progresses. We'll have more on KPRC2 News tomorrow, of course, from Chambers County. And if you missed the beginning of this, we do have just a quick recap from court. We had heard from the mother of Sarah Hartsfield back in 2020, the mother of Joseph Hartsfield. We heard from her back in 2023 when we were working on a documentary about this case before it went to trial. So one of the things that she told us is what she also said to the jury today. And so we have that recap for you to play, and we will see you again tomorrow from Chambers County. Joseph Hartsfield's family spent much of the day on the stand. They claimed that Sarah Hartsfield would get irrationally upset about little things, and they claimed that she found ways to secretly listen to their phone calls. A lot of the testimony did focus on the time and the days leading up to his death, and a fight that they say that the newlyweds had that ultimately led to him making plans, putting those plans in place to leave her, including even opening a bank account back in his hometown of Midway, Texas. So Sarah Hartsfield came to court this morning. She wore a navy pantsuit. She had heels on once again. And you can see from this video of her getting out of that sheriff's deputy's vehicle that she appeared to be carrying a Bible inside with her. Once inside the courtroom, we saw that she had a ring on her wedding finger. It's unclear if that was her wedding ring or not, but we did see then she took notes very intently throughout the testimony. She would pass them sometimes off to her attorney, Case Darwin, there sitting next to her. And she also appeared to get emotional at times in response to some of this testimony. The prosecutor warned the jury during her opening statement this morning that Sarah Hartsfield will be on and ready to perform during trial. She described her as a fighter. The defense said the state cannot prove how Joseph Hartsfield got too much insulin in his body before dying, and that Sarah Hartsfield is adamant she didn't do it. On the stand, we saw Joseph Hartsfield's mother, Helen, and his sister, Jeannie. They say that Sarah Hartsfield kept them away from their dying son and brother at the hospital, and then wouldn't let them even be at his funeral. Both of them got incredibly emotional thinking about those last days with Joseph, saying they feared for his life, especially after Sarah Hartsfield told them about some of her past experiences with her exes. Joe's mother spoke with us back in 2023 for our documentary, The Two Sides of Sarah, and she actually shared something similar then that she told the jury today. Listen.
He had been taken to the emergency room and he was unresponsive.
Were you surprised?
I won't say I was surprised at all. I expected something was going to happen. When it happened, you know, I was shocked.
So some of the family testimony, Keith, like you mentioned, focused on them finding out at the hospital that Joseph Hartsfield had other drugs in his system besides insulin. So far, we have not heard any medical testimony on that, but we've seen the witness list. I've seen several of those subpoenas that have been sent out. We are expecting to hear from many doctors throughout this trial, so we'll have to wait and see, because I expect that we will be hearing a lot more about what other drug may have been in his system when he got to the hospital unresponsive.